Hi, I'm Dave Dinkle, and I want to talk about it couldn't be done. There's no possible way, and it cannot be done, as told to me by a judge who's not on the bench any longer, her husband who is active in the real estate industry, and many attorneys who have come to me through other investors and said, you cannot do it, it will not work. To set the stage for what happened, I did a transactional funding on a property. A mortgage broker called me and said, I have the A to B side and I'm funding the B to C side, just need to close the A to B, and I have the funding in place, be funded the same day. As all too often happens, it wasn't funded the same day, so I went ahead and funded the A to B, believing this trusting person who told me all his credentials and how many deals he closes a month and who the firm he works for and so on and so forth. I called the closing agent and said, I'll be getting a note and a mortgage on it from you. Go ahead and fund the A to B. Now, she must not have heard I'll be getting a note and a mortgage from you, because typically I don't send my own out. I have an attorney for the firm draft it. It's because they have errors and omissions, and they're on site, especially in some other states besides Florida. So when I called the following week, this was a Friday, and it was an REO sale, so it had to be closed or else they would lose it. And the mortgage broker told me the funding would come through on Monday, so I called back and said, how's it going? And she said, well, we closed the A to B, but I don't have anything on funding coming in for the B to C side. So I said, did you get a note and mortgage? She said, we don't do notes and mortgages. Now, what happened here? Some kind of a dysfunctional sort of thing. So at any rate, I said, okay, so I called the guy and I said, by the way, he said, not a problem. I do notes and mortgages every day. So I'll send you one today. Today moved into 2 days, a week, and I realized, as too often happens, I trusted someone, funded the A to B side, and now he had a free and clear property that he could sell and take the full proceeds. So I did what I have been told cannot be done. First I called the closing agent and said, you've drafted these for me before, note and a mortgage. And she said no. So I called the supervisor, because I've done business with them for years. And she said, well, we don't actually do it. We have our attorney do it. So I said, well, can I have his number? So I called him and I said, you know, what happened? He said, they didn't call me. I said, okay, I'm going to go ahead and file list pendens on the property. And he said, you can't. I mean, he jumped on me. He said, now listen, my wife's been a judge for 30 years or 25 years, and I've been an attorney for 25 or 30 years. There's no chance in hell you can file a list pendens and get anything out of this. I said, well, I've done it about 25 times and it works out very well. He said, it's impossible. He said, it's absolutely impossible. If you can do it, you show me, and I'm not going to tell you the rest of the conversation because it doesn't matter. So what I did, went to my attorney, said, here we are. Now again, this is a critical aspect of what's happening. The timing is important, because if that property was put back on the market, it's free and clear. And that mortgage broker that bought it supposedly for a client is going to walk away with all the proceeds, and I'm going to be scammed. Not an unusual occurrence in people trying to scam me. And when I trust people like that, I will do it, I will do it. Trust me, those are the most fabled words ever. Trust me, don't trust me. Okay? Long and short of the story is, we filed a list pendens about 10 days later, and for almost 9 months, they fought us. They fought us going through 2 attorneys, starting on the 3rd attorney, and their case was very simple. Show us the note. Now, we could say that we could file a notice of lost note, but that doesn't matter. We didn't have a note. We didn't have a mortgage. We had nothing signed. So we went through the 1st attorney and he quit. Went through the 2nd attorney and he quit. And the 3rd attorney didn't even show up for the hearing. So what happened? When all the smoke cleared, I'm going to show you what happened. Now, this is not the check. I made a copy of it. As soon as I got the certified check from the county for the foreclosure sale of the property, I went ahead and deposited, because it doesn't matter if you see a copy of it or the real thing. The bottom line is, and I hate to show checks, when I see guys on videos say, here's my proceeds. Well, how much was your earnest money deposit? Because it's included in there. If it's an assignment, okay, that's free and clear, but you're not making enough money if you assign. I'm not going to get off on track, so I'm going to try and read this number to you. $76,374.47. How much did I pay for the property? I paid $59,000 and change. So here's what happened. In the list pendens, I filed for accelerated interest at 18%. That's what it is for us. Attorney's fees, so on and so forth. So my final judgment amount, that's it. Okay? That's exactly what I got. 18% plus the attorney's fees. So here's what happened. In this county, they're not on electronic auctions as most of the other counties in Florida. So I had to actually go because I was the one that had the final judgment. It cost me $70 to register. And I went into a tiny room with a conference table, and there was about 11 guys there. And these are old timers. And this county in mid-Florida and the counties surrounding, they make a tremendous living off buying foreclosed property as well as tax deed sales. That's their living. They've been around a long time. So I walked in, sat down, my case came up first, and every one of them knew me. And that was kind of a real shocker. I said, where do you guys know me from? And they said, we've been following your case in the public record for the past 9 months. We don't understand how you did it. We've never seen it happen before. I said, well, here I am, and I've got a final judgment, so there you go. They said, we still don't believe it. I said, okay, you don't have to. So the next thing up was, what are you going to bid? The clerk asked me, and I said to him, my final judgment's 76 and change. And they all shouted out, don't bid that, bid $100. Why $100? Because if you've been to an auction, your final judgment effectively is a credit card, and you can bid to that amount without having to put any money into the scenario because you already have that coming back to you. So they said bid $100. I knew to bid $100, but they're all teaching me. They've been in the business for probably 15 to 25 years. I've only been in for 44 years, so it's always something to learn. So I bid $100. And a guy sitting behind me and next to me said, how much are you going to take? And I said, $76,374.47, or I'm going to own it. Now, what was it? Well, when I looked it up before I funded it, I knew that it was a 1-acre lot with a mobile home. Mobile home 2002, and I had this over hurricane season. When I originally looked at the picture, what I noticed, it had a shortwave radio tower, one of those guys that's like 60 feet high and heavy steel and so on and so forth. Hurricane blew through. There's no radio tower up there anymore. And of course the grass grew to about 3 feet in height, and it's on a dirt road and it's out in nowhere. But in Central Florida where this happens to be that people like a chunk of land and mobile homes, and they pay a decent amount for them. And by the way, if I just looked at Zillow, the Zillow estimate, which is, I'm going to say, oftentimes virtually worthless, had gone from about $60,000 to $91,000 in that course of time. And the reason for it is the comparable sales in that subdivision, so to speak, were done by the guy sitting behind me. He had bought up 4 other properties. So he said to me, okay, I'm going to bid $76,475. I said, help yourself. $375, I'm sorry. So he bid $76,375. Now, if I had bid against him, think about this. Let's say I bid $80,000 and he bid $82,000, and I bid $82,500 and he bid $83,000, and we hammered it down at $83,000. All of the money over my final judgment would have gone to the scammer as overage. It didn't used to be that way in the good old days. Whoever was on title at the last minute, so to speak, before the pre-foreclosure or foreclosure sale, got the overage. But the county and the state changed that because too many people were getting deeds from homeowners the day before the sale, recording them and taking overage. So in this case, what happened is I sold it. I let him bid that amount, let him have the property for that amount. And here's what happened. I got my check for the full judgment amount plus attorney's fees, and the scammer got a check for 53 cents. 53 cents. Bad things do happen to bad people sometimes, and I think this is probably one of the chances that I got in life to say, hey, I told you so. What I want you to take away from this is the fact that I have probably, and my students have been around the country told by maybe hundreds of attorneys, you can't do that. Now, I had the husband or the wife or the judge and all that stuff tell me this, you can't do it. They don't understand it. I've talked about it in my other videos. We had a student that put a property under contract, but the end buyer decided not to come. So my student sold it to someone else, and what happened, that end buyer must have been watching my videos because he went out and filed a lis pendens against the property. Why not file a notice of interest, affidavit of interest, or anything else you want to call it? Because if an attorney closes it, he will write over the affidavit, notice of interest, memorandum of contract. It doesn't matter to him. And the title companies don't seem to care about it either. However, a lis pendens, that property is not going anywhere until that's resolved. It's a huge liability on anyone that would fund it and anyone that would issue a title policy. So it's dead in the water. So what did we do? Here in effect, we had a scammer. I'm going to say that because I know the situation in hand about why he didn't close. And he's running around filing a lis pendens on properties. So we actually went to court. And I think it took about 45 seconds for us to make the case of here's why this lis pendens doesn't apply. And the judge agreed. It's because, I'm not going to tell you why. If you don't know what you're doing, it doesn't apply. If you know what you're doing, we've taken out tons of money on sellers who have not come to closing against contracts, as well as where somebody walked away and didn't sign or didn't give us, in fact, a note and a mortgage. So there's two opportunities filing a lis pendens. Contract happens to be a lien on the property, file against a contract. It's a breach of contract. Well, go and file it in court for a breach of contract, and what do you get? A drawn out series of court hearings. Even if you get a judgment, the seller's gone. It's over with, and you're not going to collect it. However, to do a lis pendens, that property is not going anywhere. And if you say, well, what about attorney's fees? We did one in South Florida for a seller that had power of attorney for his wife who was in a foreign country. I mean, that's the worst possible scenario with the worst amount of flags ever. Power of attorney can be revoked instantly. So what did we do? Filed a lis pendens. Took it through the closing, which took almost a year. $13,000 in attorney's fees. I think it was $13,500 now that I think about it. Who do you think paid those? The seller. It comes out of the proceeds. And we didn't pay any extra for it. And in the interim, it took almost a year to do, the market went up substantially. So if you're thinking about doing this, remember, you have to put up the purchase money into the court registry. So it's not a free ride. You just go out there and do it. You have to put up the money if, in fact, you move forward and you actually get a judgment. That's in a contract. In my situation I gave you here, where I'm holding up the check from the county, different scenario. But again, the same process, but it's got to be filed under a different motion. So don't try this yourself, because what can happen if you go to an attorney and say, well, just try it, like the attorney that did it, and sanctions against him. What's a sanction? He has to pay our attorney's fees, and your attorney will know that. So if he's not familiar with how to do it, don't intimidate him into trying, or you may have to pay his fees and ours. So as I always say, I wish you limitless success, but be careful when you watch YouTube University that you get the whole story and not just enough to get you in trouble. Thanks again. I'm Dave Dinkle.